I want to go back just a little bit on a question that was asked by my colleague and dear friend from Georgia. The legal dynamic of a joint exploratory language, joint explanation language, and also rider language is that it has the same effect as a conference report, mainly for clarification, those kind of things. But can it not, is it not true that those language at times can also be used for other purposes, such as use in lawsuits or pushing a position that gives some effect to an outside disagreement?
I don't know the answer.
Okay, I'm going to go from my perspective and legal perspective is yes, it can, because it has, and we've seen this done in language in other bills such as WRDA and others in which language was expressed. And just to let you know, as your staff can catch you up, this is a Georgia issue. This is an issue that is dealing with water issues from something that really was pretty interesting. And I want to spend just a few moments here because this is important, because this is not just something that has come up overnight. This is not something that is, just been something that was not known up until today. In fact, a pretty historical letter was sent just a few weeks ago from all 16, both Republican and Democrat, from the state of Georgia dealing with this, any language that basically what we feel like infringes on the state's rights issue of dealing with the waters between Georgia, Florida, and Alabama. This is an issue in which I, on the state level, have worked on for the 6 years that I was in the State House, but also worked on while I have been here. The best solution here is for Congress to stay out. Unfortunately, there was language appropriated in from the Senate side that directly, frankly, from my opinion, and many others, including the governor of Georgia and others over the years, that have said that this interferes with the state's ability to solve this issue, which has been litigated for many, many years. The concern we have here is in not only this, but also in the joint letter of between the language here, is how do we get this out, let the governors of the 3 states solve this where it needs to be solved, and however this was put in. What disturbs me, Mr. Chairman and Ranking Member, about this is there's a lot of stuff that y'all have worked very hard on, that y'all that are in here. There's some, as many members have said, agree with, disagree with. But from us, from a state perspective, this is something that I know Georgia in particular, and I know the other states as well, have spent millions of dollars trying to solve. And it's been specifically said, keep the federal government out of this, because, again, from our perspective, as one side loses, we've won the arguments, and then we have to go back and fight something else on a new lawsuit with language that are added in as riders. This is wrong. This should not continue to happen in these bills when you have riders put on that affect basically state issue and state problems. I'm working currently with the staff. I'm working currently with hopefully leadership. I know that we're on the long end of this rope. I understand that. But this is something that affects our state. It should affect the other states that are involved in this and should not come in the form of riders. And that is become part of this issue for me, is saying why. I mean, the language that is added here is basically, in the words of some of ours, is basically taken as a slap in the face to the state of Georgia. Because this is not something that should be in here. It's not something that we should be dealing with. If a committee chair wants to actually work on this, then we'll deal with it that way. It is very concerning this language got in here. We're going to continue to see what we can work on. I want to thank you for the main part of your bill, which has, frankly, didn't come with these riders. We're going to continue to work on this and look at it. I needed to bring this forward because this is an issue that will not be fixed unless it's gone in some ways, or that we can mitigate it in some other fashion. But we shouldn't have to be doing this in an omnibus, and we shouldn't have to be doing it when, again, all 16 members of the both bicameral delegation from Georgia, both Republicans and Democrats, came together and said, this is a really problematic point for us. And now, frankly, the language that has been added could actually involve other states in the joint explanation. Actually, by putting multi-states, could actually involve other states, not just the Georgia-Florida part. And I know there may be some disagreement and legal disagreement about that, but when you look at it from that perspective, there is that issue. So with that, I've made my case. There's a lot of things still going on in this. I hope that we can continue to work for this. This is a very much of a problematic issue for Georgia. It's problematic for us. We are working on some back angles trying to fix this. But, Mr. Chairman, mainly, I just wanted to use this time to say thanks for your work. There's a lot of things in here I'm appreciative of. There's some things I'd always disagree with. But it is a shame to me that we get this kind of report language that ends up. I'll always yield, Chairman.
The omnibus blocks all Senate efforts that would disproportionately advantage Alabama over other states. We stopped a Senate proposal that would have prohibited the Corps from reallocating or even studying the reallocation of water in the Alabama-Coosa-Tallapoosa River Basin. It blocked the expansion of that proposal to the Apalachicola-Chattahoochee-Flint River Basin. It stopped language that would have elevated Florida's environmental concerns above all other concerns within the ACF River Basin. And fourthly, it halted Senate language that would have required congressional notification of any instance of an Act River Basin water user withdrawing water in excess of the contracted amount. The legislation also replaces problematic Senate report language regarding notifications from the Corps to DOJ of violations of federal water contracts involving the ACT. The new report language in the omnibus is not specific to any water basin and merely asks for a report from DOJ of any violations of water contracts reported by the Corps. However, of significant note, DOJ indicates that they have never received any notifications of violations from the Corps to date and don't expect any. So therefore, the report would not include any information on violations.
Mr. Chairman, I appreciate that, and I appreciate the staff working on that and providing that information. We're very thankful what was kept out. The problem is what was left, and there is a genuine disagreement. It's one of those things that may seem odd to you if you look at it in this piece of paper. I told you to comment on this piece of paper, and you comment on this piece of paper because that's all you see. What I don't show you is the history behind that I actually want you to comment on. And what we're dealing here is a history that involves far beyond the single focused issue of the language that has been presented in this. It was taken out in the energy and water side. We understand that, and that was very much appreciated. We've got that. But it was then turned around and added into language that is problematic and considered problematic. Again, the issue that we have here should be noted that language of a similar attempt was inserted into WARDA when it was said this is nothing but language that was a clarification, very non-combative, whatever you want to call it, language, and then ended up as being cited in a lawsuit in this case. That's why we say that this is not simply just an issue of language and how it's written. It is a fact of the 30-plus year history that this is being used for. It's used for leverage. It is used for here, and this is the problematic part that we have. I know there can be disagreements. I'm an attorney. I can make arguments on both sides. I know yours can as well. The issue we have here is we have history backing it up that this actually is problematic. And by being non-specific, and at this point not having a report is not the issue, but the gentleman who offered this would not have agreed to the language probably if it had been taken out because they want it in this way. It is non-specific, but when you think about this, when you look at back to 2005, it's an interesting date to go back to. It's an interesting date to go back to for 10 years. It's an interesting date to go back to when you say multi-state. Georgia is one of those that's involved in multi-state water negotiation problems. So I think the issue here is, Mr. Chairman, I have great respect for you and the ranking member. You're not going to be able to, at this point, unless we can strip this language, solve our problem right now. Georgia, Florida, and Alabama need to solve this.
But gentlemen,
Always.
we understand fully what you're talking about. We're talking about some way to help you solve this problem, so we'll continue to work with you.
And again, I think from my perspective, that's why I needed to bring this up and continue. You have to understand from my perspective, me and my friend from Florida, this needs to be solved with the governors of those states. They need to get together, solve this, and quit this game playing in riders to the Omnibus Appropriations Bill, because this will come back unless we can work it out and get it fixed now, and I do appreciate that. With that, Mr. Chairman, I yield back.
Gentleman yields back.
If the gentleman will yield,